Welcome. You're in the right place. My goal here is to educate you, to empower you, to protect you. This webinar is for you if you are feeling overwhelmed by debt, mortgages, student loans, medical bills, child support, IRS, and more. Today, you'll learn 3 secrets to legally discharge debt using your birth certificate CUSIP number and statement coupons. In this webinar, here's what you'll learn today. You'll learn 3 things. You'll learn the hidden truth about debt statements and coupons. Number 2, you'll learn how to leverage your birth certificate CUSIP number. And number 3, you'll learn my step-by-step REST process, my REST process to discharge debt fast. Hey, my name is Brad Tipton, and I'm your host. I'm the author of 10 books on debt discharge with over 7,000 clients successfully helped. Stay with me today and you'll gain the tools to reclaim your financial freedom. Now, here's the eye-opening truth. Did you know that every bill or debt statement that you receive includes a statement that has a coupon that can be legally used to discharge your debt? And did you know that your birth certificate CUSIP number is a financial key creditors use, right? But they don't want you to know about that. Most people struggle because they've never been taught these secrets. So stay tuned. I will reveal exactly how this works. So let's get into the 3 secrets. The first secret is decoding presentments. What every debt statement is hiding. Now, a debt statement is what's called a negotiable instrument. It's also called a presentment. And what it's doing is it's requesting something from you or demanding from you something. But here's what you didn't know. It's demanding payment or acceptance, right? The detachable coupon is your key to discharging the debt. It's a negotiable instrument. And my goal is to teach you and have you to learn how to properly endorse and accept the coupon to settle the balance that you owe. Now, I'm not going to give you my opinion. That's not fun. You want to know, and I want to teach and share with you solid information. So I will be using definitions and processes out of the government websites, out of Black's Law Dictionary, which is the most widely used law dictionary on the planet for the past 100 years. Law firms use it. Any business uses it. Banks use it. They all have a legal department. Hospitals, they have a legal department. Any big bank, any big lender, anybody like that, any of those large lenders or small lenders, they all use Black's Law Dictionary to write their forms, to write their statements, to write their notices. They also refer to what's called Burton's Legal Thesaurus. And so that's widely used. I don't know of any other thesaurus that's used along with the dictionary as widely as Burton's Legal Thesaurus. And so that's what I will be using to share with you today. So it's important to know that when you receive a statement in the mail, right? Let's say a monthly mortgage statement or a car note statement, wherever it is, that's called in the legal world, that's called a presentment. And the reason is because it's being presented to you, right? That's why it's called a presentment. And by the way, you see these things in yellow. I've highlighted these areas in Black's Law Dictionary to let you know that the things that I'm sharing with you today are based upon law, not my opinion, not what I think, not what somebody else online, some so-called guru thinks. I'm providing you solid information based upon case law out of Black's Legal Dictionary, right? So you see the areas in yellow. Now, if we go down further to the area right here where it says the production of a negotiable instrument, what it's saying is a presentment or your monthly statement is the production of a negotiable instrument. You go, Brad, well, what does a negotiable instrument even mean? Well, I'm 61 years old, all right? So back in the day, we didn't have internet, we didn't have direct deposit. Every other Friday, we would receive a check on our desk when we walked in, and the check or the envelope on our desk every other Friday when we walked in. And in the envelope was our paycheck. And the paycheck had the check itself, and it also had what's called the pay stub. Now, On the bottom of the pay stub, it would always say not negotiable or non-negotiable. And what that means is we didn't give this to you to deposit. You can't, we didn't give it to you to deposit. Don't deposit the pay stub. But on the other side of it was the paycheck. And it didn't say anything. It didn't say, negotiable, right? Because the rule in law is it's negotiable unless it says non-negotiable, right? And what negotiable means is that somebody gave it to you, somebody mailed it to you, somebody handed it to you, somebody sent it to you. That makes it negotiable, and it's negotiable for money unless it says not negotiable. So when you receive a presentment in the mail, it's negotiable, right? And it can be deposited. And so it's a negotiable instrument to the drawee for his acceptance, right? So there's someone called the drawer, like you're um, let's say you're dealing with Wells Fargo. Wells Fargo is the one who drew up that presentment and sent it to you, right? So they're what's called the drawer. You're what's called the drawee. You're the one who's receiving it. So the negotiable instrument is sent to the drawee for his acceptance, right? You see that? For his acceptance. You're like, what does that mean? Right? Let's go down a bit farther. It says a presentment is a demand. Well, when you receive your monthly mortgage statement, you already know it's a demand. You're not confused about it's demanding something from you. But in the red, let's look and see what it's demanding. So the presentment is a demand for acceptance or payment, right? So let's say you get your monthly mortgage statement in the mail. There's a coupon on the bottom, and your first thought is, oh, they want payment. But you never thought that they want acceptance. You never even heard of that word acceptance. But here it clearly says in Black's Law Dictionary that your monthly mortgage statement, your presentment, your child support statement, your IRS statement, your medical bill, whatever it is, it's a demand for one of two things: acceptance or payment. My job today is to show you how to keep your money in your pocket insofar as payment and use acceptance to settle the debt. That's the powerful part here. So let's talk about something. Now, you are aware, if you get this, you're grown like I am. When you receive the monthly mortgage statement or your car note or the medical bill or the IRS or whatever the case is, typically on the bottom, right, there's something that's called a coupon. Well, here's from I'm sorry, this is from Burton's uh, Legal Thesaurus, where it shows coupon. If you see right there on the right side, it says coupon. Now, let's look at the definition of a coupon, because I want to show you these definitions because they may be different than what you thought initially, right? That's why we're here, to educate you, to empower you, to protect you so you can utilize these things for your benefit, right? So a coupon is an allocation. Well, I'm not sure what that means. It's a card. Okay. It's a certificate. Oh, okay. It's a check. So when you receive your monthly mortgage statement in the mail, or your car note, or your medical bill, or your IRS, or your student loan, did you know that on the bottom is a coupon, which is also a check? That's what it says right here. It's an allocation, it's a card, it's a certificate, it's also a check. It's also a credit. You're like, what? I didn't know it was a credit. I thought it was a debt. No, the coupon is a credit. It's the detachable part of the certificate. It's the detachable portion, right? And I won't go through everything. I'm just kind of read through here. Um, what I like is on the bottom, you'll see where it says separate, it's the separable part of a certificate. Separate the ticket, share out the slip, the stub, the ticket, the token. But wait a minute, let's stop. It's a voucher. You're like, a voucher. What does that even mean? The coupon on the bottom of the statement is a check. It's a credit, and it's a voucher. Now, I'm not saying this. I'm going to the legal documents and I'm showing you what it is, right? So let's go back to uh, Black's Law Dictionary, legal dictionary, and let's look up what a voucher is, because we already saw that the presentment that you receive, you've got two options. You can do either payment or you can do acceptance, right? And on the bottom of, and to do the acceptance, you need to use the coupon, which is also a credit, which is also a check, which is also a voucher. Well, what is a voucher? Well, let's read it here on the right side. It's a lot of different things. I'm not going to go through all of it, but it's an acquittance. Have you ever heard of a court case where the person being charged is acquitted, off the hook, free, right? That's what it is. The voucher, the coupon on the bottom of your statement is it's an acquittance. It's a release. It serves as evidence of the payment. And wait a minute, it's the discharge of your debt, right? And that's what I'm looking to help you to do, to discharge the debt, to take the presentment and use the coupon on the bottom to discharge the debt, right? Now, but it just, you have to do things right, and you have to do what's called an endorsement. You can't just go, yeah, I got a check. Yay, I expect angels to just come and make it right. No, you got to do what's called an endorsement. So let's go back to the legal, to back to law, to Black's law. Well, what is an endorsement? It's where you have to do the acceptance. The endorsement is the acceptance, right? Let's see if we can go back. I'm not sure if we can go back. I was trying to see if we can go back to our previous slide, but if you remember on that one slide, it said that a presentment, right, is a negotiable instrument that's sent to the drawee, which is you, for either acceptance or for payment. But so your question is, well, hey, if I don't want to do payment, how do I do the acceptance? Glad you asked. You have to get the coupon on the bottom, right? Which is also a check, which is also a credit, which is also a voucher. And the voucher is the release. The voucher is the acquittance, but the voucher must be endorsed, right? Why? So that you can do the acceptance, because that's what it said originally. When you receive the presentment in the mail, you have to do either payment or acceptance. An endorsement is how you do the acceptance. I don't know if you're hearing what I'm saying, but that's very powerful. Imagine you get a $500 and $512 house note in your mailbox, and instead of going into your bank account and sending $512 out of it, because you never knew that your options were payment or acceptance, you just thought the only options were payment, right? But now you look in the legal dictionary, and it tells you that you can do either payment or acceptance. And the way you do acceptance is you go to the coupon, and the coupon is a credit, and the coupon is a check, and the coupon is a voucher, and then the voucher is the release, the voucher is the acquittance, and then you have to do what's called an endorsement so that you can do the acceptance. So that's powerful. That's secret number one. You didn't know that on that presentment that you received on that monthly statement, car note, IRS, student loan, you didn't know that you had another option other than payment to settle the debt. But now you know you can do acceptance, right? Secret number two is unlocking the power of your QSIP number. The birth certificate QSIP is the financial key. Your birth certificate, and I know a lot of people don't know this, never heard this, is linked to a financial instrument with a QSIP number that creditors use, right? And so you have to discover how to locate your QSIP number and then include it in your debt discharge process, what I just told you about when you do your acceptance. And I'll talk to you a little bit about common mistakes and myths about the QSIP. Now, like I said, it's your birth certificate. And most folks don't realize, because there's a bunch of numbers and things on the birth certificate, but most folks didn't know that typically in the upper right hand or in the upper left hand, there's a number. And you can typically take that number and go to what's called fidelity and use the process of that's on my uh, QSIP checklist, put that number in there and find your QSIP number. And typically the QSIP number is worth several $100,000, if not millions. And that's the money that is used when it comes to discharging the debt. Because you go, man, well, how does it even work, Brad? If I don't send the money out of my checking account, well, how does it actually get settled? And typically it's the QSIP value that does that, right? Right. You get your QSIP number, you get the monthly mortgage statement, you endorse it properly, and you include your QSIP number, and you mail it to the debt collector. That's it. Secret number 3 is how to use my what's called REST process, right? And I call it REST process because it's designed to be easy. It's not difficult. It's not hard. Your role is to utilize it and then just sit back and wait for the debt to be discharged. That's why it's called REST, right? It's about a rapid, empowering, and secure debt discharging, right? Right? It's a secure way to discharge debt. Now, the R in the REST process means rapid reversal. Whenever you receive a debt or invoice, a monthly statement, a bill in the mail, please don't let it just sit. You have to do what I call rapid reversal. You have to get on it right away, endorse it right away, and get it back to where it came from the lender, or the bank, or from whoever debt collector right away. So you got to get on it. This is not something you can let sit around and then finally get around to it because there's some. We'll talk about this in a little while of the Fair Debt Collection Practice Act and these consumer laws and the consumer laws that protect you and give you the power to do these things that I'm talking about. They all work on a time frame, and you got to move on these things properly. So rapid reversal, get moving, endorse everything and reverse it and get it sent right back out of your house as soon as possible, right? Now, the other thing about it is whenever you send the endorsed coupon, right, you have to include a notice. And I help you to write up the notices and everything if you want. The notices are what you send to establish a contract saying, look, I want you to know here's my acceptance, here's my endorsement. I'm sending it back to you according to the laws of what's called the UCC, the Uniform Commercial Code. You say, I'm sending it back to you. These are the terms and conditions under which I'm expecting my debt to be discharged. I'm expecting my release of lien from my house, from my car, or I'm expecting my student loan debt to be set at zero. I'm expecting my IRS debt to be set at zero, whatever it is, right? You have to create a contract by sending a notice, right? That tells them what to do, right? Because typically the individual who receives the debt, like when you send your notice back to them, the average person that receives that, they don't know what to do. They're just, oftentimes an entry level employee whose role it is to work at the lockbox, receive the checks and the money, whatever the case is, and apply it. That's all they know to do. So when you send an endorsed coupon back to them or voucher to them, right, to settle the debt, they're like, what is this? Just like you never knew what it was, right? No, nobody ever told you this stuff that I'm telling you. Well, they don't know either. So that's why you have to include, right, the the notice with it, which establishes a contract. And when they receive that, they're going to look at it and go, I don't know what this is, but I'll give it to my manager. And then the manager will up the chain until it gets to the right person that knows how to discharge the debt, how to work the contract to discharge the debt. The other thing about it is the S. Always settle the debts in full. Some people say, "Hey, Brad, so if I have a $500 $100,000 mortgage, right, and my monthly payment is only $375, right? Do I do the acceptance for $375? No, no, no. You do the acceptance because typically on the coupon there's little boxes or a line that says amount included, right, or something like that, right? Please put the entire balance that's still owed. So you always want to settle the debt in full, right? That's what the S is for. Settle the debt in full by doing the acceptance and the proper endorsement. And finally, T This is something that you never want to have to do, but you may have to do it. Take enforcement action if necessary, leveraging your local court system. Please understand that the things that I'm talking with you about today they fall under what's called consumer protection laws, federal and local and state consumer protection laws. And you go, why do we have these consumer protection laws, Brad? Because you have to understand businesses can be ruthless. And what happens is they have to be held at bay. They have to be held in check by federal laws. Otherwise, they will just run rampant and take everything from you and mistreat you every which kind of way. So if you do everything that I just talked about with the R, the E, and the S, but for whatever reason, the lender won't discharge the debt or set the account balance at zero or whatever it is, or send you the lien release for your house or for your car or whatever it is, or the medical debt at zero or the IRS debt at zero, you're going to need to contact the court and say, hey, I did everything I was supposed to do. I did it properly, but for whatever reason, they didn't discharge the debt. So what happens is you take your documents and you give those to the court, to the judge, so the judge can look that over, and then the judge can be the one to enforce the settling of the debt, right? You have to understand that not everybody in business is a nice choir boy, a choir girl. Sometimes they will push back. Not all the time, but sometimes they will push back, and you may need to take the issue to the court and say, "Hey, look, I'm being violated here, right? They are misusing me, they are mistreating me, and they are violating the consumer protection laws." And the judge may have to give you um, what's called the remedy by getting the debt settled for you. Understand that anytime, and we talked about this a bit, I said that whenever you send the acceptance, you have to send a notice, and the notice is a contract. The notice sets up a contract. And like I said, in all of my programs, I show people how to do this. So I want you to know that if it sounds a little confusing, don't feel like it is, because if you want to, you can always join one of my programs and I can walk you through it. But if you see here through Black's Law Dictionary, you see where it starts here at the top, at the lower right of this top right. The word contract starts there, but it goes down on the left side, down, 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 and then it goes over to the right side, down, 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 down. I just didn't take a picture of all of it. I just want you to know that all of that is the definition of a contract in the legal world. So that's why it could be so confusing. That's why the average person doesn't know it. So I'm not going to read all of that to you, but in the upper right hand, you can see where it says contract. And it says a contract is an agreement between two or more persons. What's really interesting is that in law, corporation is looked at as a person. You would typically think that a person is, right, like slapping my hand, right, flesh and blood. No, no, no. In me and your world, yeah. I saw a person the other day, they were driving the car down the street, right? That's me and you talking. That's what's called a Merriam-Webster dictionary definition of person. But the Black's Law Dictionary definition of person includes corporations, right? So contract is agreement between two or more persons which creates an obligation to do or not do a particular thing, right? And so when you send in your uh, endorsed coupon voucher, you have to let them know what's going on so that you create a contract for them to do some particular thing, which is to settle the debt and set the account balance at zero within a specific period of time, right? And you include all that in there. That's how that works. I talked to you about, you must understand that the things that I'm speaking with you about today are not some things that I made up, right? That I dreamed up. There's something called a Fair Debt Collection Practices Act, and it falls under consumer protection to protect you against businesses that won't act right, that won't do the right thing, right? You see here in the upper part of this along the top line, you see where it says enforcement, policy, advice and guidance, news and events about the FTC, right? The Federal Trade Commission. You see where it says enforcement, right? That's what it is. That's the next page there. It says enforcement. So sometimes you'll have to enforce your rights. Sometimes you'll have to enforce your rights, and that's what the FTC is there for. That's what the courts are there for, because understand this, they wouldn't need to be there if banks, if credit companies, if collectors acted right all the time. There would be no need for this page. But there is a need for this page sometimes, and that's why I run a law office, and that's why many of my clients say, "Hey, Brad, how do I write up the documents? How do I write up the motions? How do I write up the right notices to begin to enforce this thing because I'm being mistreated?" And that's what it is, right? So that's what that's for. I also use something that's called the Uniform Commercial Code. It's important to understand that in America, we have 50 states, right? And each state has its own rules and regulations about how things should be done, right? But we also live in the United States where we're one entity, right? Not 50 separate entities. So we have the Uniform Commercial Code, which is federal, right? It's all 50 states rolled into one, how they have to act and how they have to do things and how things need to be done. It's all 50 states rolled into one, right? That's called the Uniform Commercial Code, right? But also each state has their own version of the Uniform Commercial Code, right? And they all, but whether it's the federal or whether it's the state, they all have what's called rules regarding negotiable instruments. Now, I know I'm getting way into the weeds, so I just want you to know that when you receive a monthly statement in the mail from your car, from your house, from IRS, or from student loan or whatever, it's called a negotiable instrument. And there are federal laws that govern how you need to endorse it and send it back. And these laws also tell businesses, corporations, banks, collectors, lenders, whoever, how to apply everything to set the accounts balances at zero, right? So they have this negotiable instruments piece. And inside of that, I can go a little bit deeper. And this is the federal level where it goes way into that. So I just want you to know again that the things that I'm sharing with you is not something that I dreamed up. I want you to see that I'm giving you proof of these things so that you go, wow, I didn't know that, Brad. Right? Yeah. Not only is there proof from me, but there are legitimate government websites that I'm showing you that show you how to do these things. And I've learned this over the last 11 years. Like I said, sometimes, unfortunately, if business won't act right, you will need to take, and this is a last resort, and we do all kinds of notices and things first before we take legal action, right? And before you need to take legal action. And I just want you to know that this is a last thing where nobody wants, because what's going to happen is if you get into a situation like a court, the judge is going to say, hey, did you, the judge is going to, what you're going to say is, Judge, I did everything I could. I did the endorsement. I mailed it off properly. I sent the notices. I put up the right contracts. I did it according to the Fair Debt Collections Practice Act. I did everything according to the national UCC. I did everything according to my local UCC. I sent it in. I reached out. I provided the notice, but they didn't discharge the debt. Right. And the judge is going to say, well, how many times did you reach out? You say, well, once I didn't hear back from them, I sent them a quick reminder. And again, my programs all show you how to do that. And you say, and then after I sent them a reminder, I still didn't hear back. So I sent them a final notice saying, hey, if you don't settle this thing, I got to take you to court. And I gave them more time to settle it, and they still didn't do it. So that's why we're in court, Judge. The judge is going to say, hey, did you receive the first notice? Yeah. Did you receive the endorsements and everything? Yeah. Well, did you set the account balance at zero? No. The judge is going to say, well, why not? And they're going to say, well, I don't remember receiving exactly. And that's when you say, well, Judge, I have my receipts because I sent everything via United States Postal Service. I sent it registered mail. I've got the signed signature that they received it, and I have the return receipt. And then that's when the bank's going to say, oh, yeah, that's right. The judge is going to say, great. But did you discharge it or not? No. The judge is going to say, okay, that's weird, but okay. Did you receive the second notice? And now the attorney for the bank is going to know that you have all your receipts and stuff. And the attorney's going to say, yeah, we received it. And the judge is going to say, well, why didn't you discharge it? Well, I don't know. And they're going to give some him and haw answer. The judge is going to begin to get really impatient right now because judges, they're not sweet. They're hard sometimes, and they need to be. That's all good. So it's going to say, did you receive the third notice? Yeah. Did you discharge the debt? No. The judge is going to say something like, you know what? You're wasting this court's time. And I don't understand what your problem is, but my judgment is for this plaintiff, because that's you, because you're bringing the case. You're the plaintiff, and the bank is a defendant. My judgment's for the plaintiff. Set the account balance at zero. You got 30 days to do it. You're going to be held in contempt of court. And that's how it works. And then you'll notice that you'll get the discharge. But again, this is in the minimal amount of cases. This is the last ditch effort, right? So here's my thing. Well, I mean, I'm explaining it because I've been doing it for over 10 years, almost 11 years. I've worked with over 7,000 clients. So I make it look easy doing this tightrope. I call it like a tightrope walk. You got to learn how to do this thing. You got to learn how to navigate this stuff. So here's a few FAQs that we get all the time. What types of debt can be discharged with this program? This program helps with any type of consumer debt. IRS, student loans, medical bills, personal loans. We get a lot of people that come to us and say, hey, look, it was a debt coming back from a long time ago, and now some debt collector that they have no idea about is calling them. And we provide you with the process to deal with them. And one of the cool things about that is one of the processes is when somebody calls you that you don't even know and they're trying to collect the debt, your role is to be pleasant. They're going to say, hey, this is Jack Smith calling from, XYZ collection agency. You owe us $10,000, right? You're like, whoa, I don't even remember that, but okay. But you say, now, what is your name, please? Jack Smith. Okay, Jack, thank you. And is this call being recorded, Jack? Yeah. Yes, it is. It's being recorded. Every call. These calls are being recorded for customer service. And you're like, they go the whole 9 yards, right? And so you ask him his name, you ask him the name of their business, you ask him the address of their business, and you ask him his full name and his ID number. And you let him know that I'm so glad that you called. I want to get this debt settled. That's the word that you use, as soon as possible. So, Jack, would you please mind just whatever bill or invoice or statement you have, would you plop it in the mail for me so we can get it taken care of right away? Well, I want to take care of this over the phone. That's why I'm calling you today. You say, and I appreciate that, Jack. I really do. But you have to understand that anybody who's grown understands that if it's business, it really needs to be in writing. So if you would please, Jack, I'm just asking you if you would please put it in writing, drop it in the mail, send it to me, and as soon as I receive it, I'll get this matter settled immediately, not later, immediately. Is it okay with you if I get this thing settled immediately, Jack? Yeah, of course. Well, great, Jack. Now, what mailing address do you have for me? Right? I have 12345 Main Street. Yeah, that's our old address from 10 years ago. We actually live at 654321 Elm Street now. Would you be able to send it there? Yeah, great. All right. Well, that's it on my end, Jack. Is there anything on your end? Well, no. Oh, great. I'm looking forward to this so we can get this thing settled immediately. Is it okay with you if we settle it immediately? Yeah. All right. One more thing, Jack. Um, would you please do me a favor and please put me on your do not call list? Right. Well, or we need to call out just to make sure. I understand that, Jack. But this call is being recorded. Is that correct? Yes, it is. Well, great. Would you please put me on your do not call list? And going forward, if you have any communication or anything that you need from me, please put it in writing. That's the best way to do things when it comes to business. Is that okay? Can you put me on your do not call list? Yes. All right. Well, Jack, that's it on my side. Anything from your side? No. And you hang up. He's good. You're good. That's how you handle it, right? That's how you do it because you want that statement to come to you. You want that coupon on the bottom. You want to be able to do an acceptance, right? So that you don't have to do a payment. You want to be able to get the credit. You want to understand that it's a check. You want to be able to endorse it. You want to be able to send it back with the proper notice to establish a contract to get the debt settled. So you got to get that from Jack to get the debt settled. Hey, Brad, number two, how long does a debt discharge process take? Well, it takes about 45 days, sometimes slower, sometimes longer. It all pretty much depends on the internal processes of the debtor, the debt collector, the banker, whoever. They go fast, it goes fast. They go slow. I had one lady, she reached out to me and she had been in the program for just under a month, I think, right about a month. And she received in the mail something called a 1099 form. And it was for like $64,000, 86,000. I don't remember the number. This was a couple years back. She said, Brad, what is this? I said, oh, what it is they discharged the debt and they sent you a 1099 form. And the 1099 form is letting you know the amount of the debt that was discharged and that the IRS may look at that as income and tax you on it. So she's like, so the house is paid off? I'm like, yep. She's like, so I got no more house note? I said, apparently not. Right. And so she was just as happy as she could be. Right. Those are the kind of stories that I want for you. Right. Simply say, hey, Brad, is there a limited number of debts I can submit? No. I mean, you can, this is a skill. Once you understand the process, there's no limit. It's not like you have to submit them. Right. This is you. I mean, you discharge as many as you want. Discharge them for your mom, for your family, for your cousins, whoever, right? Start your own business, whatever, right? That's that. What happens if my debts are not discharged within the average time? Well, most debts are discharged within the average time. Some may take longer due to the creditor or debt collector's internal processes or times. We've never seen it fail. Do I continue to make monthly payments on my debts? No, according to the Fair Debt Collections Practice Law, federal law says once you do this, don't make the payments, right? So that's what the law says. This is not mine. Um, and you can go look that up on the Fair Debt Collection Practices Act, FDCPA. You can look that up on their website if you want. And so that's that. Number 10, I've heard that you have to have a special status or become a secure party creditor to discharge debt. Is that true? No, that's no longer true. Um, As it relates to debt discharge, the process is always evolving. So since COVID-19 ended, you no longer need any type of special status to be or be a secure party creditor to discharge debt. I had a guy yesterday. He owed child support in Michigan over, I think it was 92 or $97,000. Right? I want my money back. It's like, bro, you don't want your money back. What you want is $92,000 worth of debt off of your head, and you want us to fight until you get it. That's what you want. He's like, yeah, right. Again, my name is Brad Tipton. I've been your host. I promise you it has been my pleasure